Hey guys, it's Harmony. I'll be doing the video on is capital punishment a bad public policy? We are for the yes side. I did this with Victoria, Cameron, and Mayra. So first we're going to do a little background information on the death penalty. Alright, since the nation was born in 1776 to 1972, the death penalty was mainly carried out in the form of a public execution by hanging. A quote we found is, "A disproportionate number of the people executed under these customs were black. Many of the people that were executed were also found to be innocent later." Before going into some of the courtroom decisions that shaped the death penalty, it is important to remember the Eighth Amendment and the influence it had over the death penalty. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. The last part of the Eighth Amendment, nor cruel and unusual punishment inflicted, is the main argument against the death penalty. Furman versus Georgia is the death penalty case that was ruled as cruel and unusual punishment by the Supreme Court in 1972. Furman argued that it was cruel and unusual punishment under the Eighth Amendment. He also argued that because he could not receive an impartial jury, that it went against the Sixth Amendment as well. The Supreme Court had to face the idea that the intended purpose of the death penalty was not the reason people were being sentenced. It was rarely carried out, so Furman argued that it no longer served as any deterrent purpose. Furman also provided evidence to show that the death penalty was overwhelmingly used against the poor and minorities. According to Gross in 2018, less than 1% of felony convictions in the United States are murder convictions, and maybe 1/100th of 1% of felony convictions are death sentence. The death penalty was created to punish murder convicts, so it was obviously not punishing the intended offenders. Even after many revisions of the death penalty that led to it being restored in 1976, there was a lot of issues that were never addressed or dismissed. The jury and the judge still had a lot of discretion with the admission of aggravating and mitigating factors in 1972. It was still a matter of judgment rather than fact, which did not resolve but worsened the issue of the death penalty being arbitrary. Now we'll go over some arguments against the death penalty. First, we have a few ethical concerns regarding the death penalty. Capital punishment raises significant ethical questions. The practice of intentionally taking a human life is inherently controversial. There is a substantial risk of executing innocent people. Wrongful convictions have occurred, and DNA evidence has exonerated many death row inmates, understanding the fallibility of the justice system. For example, the case of Cameron Todd Willingham in Texas, who was executed in 2004 for arson murder, was later revealed to be based on faulty forensic evidence, raising serious doubts about his guilt. Subsequent investigations and new evidence raised significant doubts about the validity of his conviction. The debate over whether the death penalty constitutes cruel and unusual punishment has persisted. Arguments are made on both sides, with some advocating that it violates the Eighth Amendment of the U.S. Constitution. Next, we have racial injustice. In an article by Fox in 2018, he discusses how the death penalty is breaking the Sixth Amendment because it is impossible to have an unbiased jury. In a study done by Nassif et al., they found that white jury members vastly outweighed the black jury members. Goetting found in 2022 that the percentage of prosecutors who decided to seek the death penalty were 19%, while white defendants killing black victims, and 70% in the case of black defendants killing white victims. Going back to Fox's article in 2018, he cited a study done in Georgia that found when the victim of the murder trial was white, that made death row 4.3 times more likely for the defendant. Fox also cited an analysis by Beckett and Evans that the death penalty is 4 times more likely with a Black defendant. According to the website Equal Justice USA, various studies have found that the death penalty cases are more expensive compared to non-death penalty cases. Most of the expenses come in the form of legal proceedings and hours spent by legal courts. Some of the reasons why it costs so much for someone to undergo the death penalty procedure is because there are more complications involved. There are more witnesses, more experts, more lawyers, longer trials, more emotions, and an entirely separate trial for sentencing. Furthermore, many of the cases are also overturned through appeal, which involves even more expenses. According to a Columbia Law School study, about 68% of death penalty cases end up being overturned. Not to mention that most of the death penalty cases are never even actually imposed and rarely carried out in the end. The death penalty is merely a waste of states' money, which comes from taxpayers' dollars. According to a study by the Criminal Justice Department of the Seattle University, the average total cost to the justice system related to pursuit of the death penalty are about 1.4 to 1.5 times more expensive than death penalty not sought cases. The study examined 147 first-degree homicide cases since 1997 with aggravating circumstances. Families and associates of the victims often have to go through additional procedures when it comes to death penalty sought cases. Family members may be asked to testify at the sentencing phase to give out victim impact statements. According to the Death Penalty Information Center, victims' family members who oppose the death penalty are sometimes ignored if the prosecution intends on seeking the death penalty. The Death Penalty Information Center highlights the voices of victims' families because they see the importance and uniqueness of their perspective on the death penalty. So, some quotes that we found are, "Proper justice is not about seeking revenge or retribution. Our great losses can never be repaired or remedied." Another quote is, "Studies suggest the death penalty does not bring closure and interferes with their healing process." Phone polls have shown a long-term decline in public support for the death penalty. In phone surveys conducted by Pew Research Center between 1996 and 2020, the share of U.S. adults who favor the death penalty fell from 78% to 52%, while the share of Americans expressing opposition rose from 18% to 44%. Interestingly, support for the death penalty remains low, even though there has been a perception of an increase in crime. This indicates that public sentiment is not solely driven by perceptions of crime rates. Now we will address a few arguments that support the death penalty. The deterrence theory is based on the assumption that humans are rational beings with free will, meaning that we have the choice to commit crime or not. This theory also assumes that humans are inherently self-interested, and the only way for humans to follow the law is by making the cost of crime higher, by having punishments that deter people from committing crime. Many people argue that the death penalty is a form of punishment that deters the public from committing crime through general deterrence. General deterrence attempts to prevent the public from offending in the first place. There are certain elements of the deterrence theory that need to be present in order for this theory to function at all. Punishment needs to be severe, swift, and certain. Long legal proceedings, including drawn-out appeals and complicated procedures, are a common problem with the death sentence and can cause significant delays between sentencing and execution. Some factors that prolong the legal proceedings are due process, mistake convictions, and public opinion. Due process is because the death sentence legal system is complicated and has many safeguards in place to prevent unjust executions. This frequently entails numerous appeals and reviews, the completion of which might take many years. Mistake convictions. Time-consuming reviews and appeals are required in the event of a conviction or the development of new evidence. Public opinion. Shifting public opinion and changing social norms may result in legal and political discussions over the death penalty, which may have an impact on how it is carried out. According to a study by the University of Michigan State published by Criminology and Public Policy, it was found that there is no evidence of a deterrent effect attributable to death penalty statutes. Synthetic and augmented synthetic control estimators indicated that the moratorium resulted in non-significant reductions in homicide rates. The research focused on 4 states which imposed moratoria on the death penalty. These states were Illinois, Pennsylvania, Washington, and New Jersey. The study examined homicide rates in the states in the years when the death penalty was temporarily prohibited. None of the states saw an increase in homicide rates during the years after the said prohibition. New Jersey even had a reduction in homicides, even when considering other influencing factors. And there are loopholes in deterrence theory itself. Loopholes include disregard for deterrence theory due to contextual and environmental elements that can motivate criminal activity, such as peer pressure or opportunity. Backlogs in the courts, lengthy appeals, and delays in the legal system create loopholes because the perceived immediacy of the penalties is diminished. In some situations, people may be less receptive to the prospect of punishment due to conditions like mental illness, despair, or addiction. According to the Vera Institute of Justice, prison conditions in the United States today are harsh, restrictive, and dehumanizing. In addition, according to multiple sites, these conditions are only getting worse. However, it is important to remember that incarceration is also a form of severe punishment, and not relief or eternal peace like death can be for many death row inmates. When taking a retributional approach, death could be, to some extent, an escape from the suffering and demise that a criminal might deserve for the most horrifying and inhumane crimes they committed in their lives. Life without parole is a better punishment if death is viewed as an escape from responsibilities and suffering. Last statements from executed offenders show just how at peace with themselves and see how the death penalty is a release from the prison that life was for them. Life can be an even worse punishment than death for many. The death punishment is often what many death row inmates desire. The death penalty serves no retribution purpose if viewing it from this perspective. Various initiatives are in place to address the issues surrounding capital punishment. These reforms aim to improve the fairness and reliability of the system. The American Bar Association's Death Penalty Due Process Review Project seeks to enhance the fairness and accuracy of the criminal justice system concerning the death penalty. They work on identifying and addressing issues related to due process and fairness in capital punishment cases. The Innocence Project, a non-profit organization, focuses on exonerating wrongfully convicted individuals through DNA testing. They have played a pivotal role in overturning numerous death sentences. Numerous organizations and movements are actively working towards the complete abolition of the death penalty. These groups engage in advocacy, litigation, and public awareness campaigns. In conclusion, the death penalty's history is full of disagreements and wavering decisions. The death penalty brings forward ethical concerns, racial injustice, expense disputes, and ignorance of families. Deterrence theory cannot be effective if one is to receive due process, and the death penalty can be seen as an escape.